This presentation will examine the history, development, and current state of the legal system of Australia and the United States, along with their positions on the freedom of expression of their citizens, an underwhelming freedom in a land down under. Australia is nearly 10,000 miles from the United States, with a current population less than 1/10 its size. Yet both countries share a unique connection with shared values, partly based on their shared history of British rule prior to independence and the establishment of the English common law legal system as the basis for what has matured into their successful liberal democracies. The US declared independence from England in 1776, 125 years before Australia in 1901. The US Constitution was influential to Australia in the development of their own, with both countries requiring equality of states and the delineation of powers of federal government representatives. Both nations require federal legislation to be passed by their popularly elected legislatures and an independent judiciary system with the US Supreme Court and the High Court of Australia, both of which interpret their constitution as their final court of appeals. Australia is a constitutional monarchy, with a British head of state represented by a prime minister chosen by the governing party of their house. The US is a republic with a head of state elected directly by its people. Another significant difference between the two countries relates to the right to vote. Whereas in the United States, where voting is a right for citizens, but not compulsory, in Australia, voting is a requirement for adult citizens in federal elections. Australia does not share an equivalent right of free expression, a foundational human right available in other democracies. The Constitution of the US and its Bill of Rights prohibit laws allowing its government to restrict expression. Australia's constitution refrains from explicitly providing fundamental rights to begin with, including the right of free expression. Australia's High Court has declared an implied political speech protection based on their constitution's declaration that their legislature be composed of members directly chosen by the people. A 1992 High Court decision in Australian Capital Television versus Commonwealth ruled federal laws invalid if they infringe this implied speech, and noted constitutional framers had deemed a Bill of Rights unnecessary, trusting in their representative government to protect rights. Their High Court ruled in Comcare versus Banerjee over the termination of a public servant who criticized Department of Immigration policies, the department employing her. Before the ruling, there was hope that the case would protect from the government further encroaching the free expression of its citizens. Instead, the High Court ruled that the Public Service Act allowed for the termination and declared the implied freedom of political communications based on a restriction of legislative power, not a personal right of expression. The case was made that government employees need a guarantee of objectivity and public perceptions of neutrality, deeming Ms. Banerjee's communications a violation. The US Supreme Court has set exceptions to freedom of expression in specific situations, such as in Pickering versus Board of Education and Connick versus Myers, declaring that public employees' free expression cannot be violated if of great public concern, if they do not obstruct their duties as an employee. The court later ruled in Garcetti versus Sabalos that public employees' freedom of expression is protected when outside their official duties. Banerjee would have concluded differently in the US than Australia. The public tweets Ms. Banerjee made were not personal. They were critical of a common series of issues of public concern and made outside her capacity as a government employee. As such, the Supreme Court would have deemed Ms. Banerjee's expressions protected and her termination unjustifiable. Australia is the only Western liberal democracy not to have some form of human rights bill or charter. Constitutional verbiage like equal protection and due process was deemed unnecessary due to the belief that common law and the responsible system Australian founders intended to create would protect such rights. An additional concern centered around systemic racism of the region, with such rights undoubtedly a compromise to their systemic ability to discriminate. Not all felt it important to omit a statement of rights. Richard O'Connor attempted to convince colleagues to agree to such a document during the Constitutional Convention. He advocated, "We are making a constitution which is to endure for all time. We do not know when some wave of popular feeling may lead a majority to commit an injustice by passing a law that would deprive citizens of life, liberty, or property without due process of law." His attempt lost in a vote of 19 to 23. Edicts demanding impartiality of personal expression are frightening, and more troubling when the government polices only negative expression when, according to its own rules, positive expression is just as problematic. Banerjee invigorated the permission of government agencies to police their citizens outside the workplace who should not have to relinquish their rights based on employment. Justice Edelman wrote in the Banerjee decision that the code of conduct aimed at neutrality casts a powerful chill over political communication, and noted that citizens of the US do not surrender their rights by accepting a governmental employer. The Banerjee ruling created a two-tier system of Australians, those employed to keep the government running, and everyone else. It proclaimed that while the second group of citizens may express themselves without fear of retribution, the former are silenced second-class citizens. Though the Public Service Act, which Banerjee relied upon, stipulates that public servants must remain neutral, had Miss Banerjee tweeted glowingly about the same policies, it is hard to imagine she would have been fired with such a case-setting precedent within the highest court of the land. There is no known record of a single Australian public servant who has been terminated for complimenting their government. The balance between one's ability to freely express themselves and their government's ability to regulate that expression is out of equilibrium in Australia. It's not because of specific verdicts, but a lack of protections central to the execution of a democratic society without fear of government reprisal. Australia's High Court decisions have been based on limited input from founding documents which produce a clouded understanding of implied law, giving their government permission to intrude upon private lives, regardless of consequence. Their court system is not the place to determine whether its citizens should have the right to express themselves freely. Instead, it is up to the Australian legislature, on behalf of the people they represent, to amend their laws so the courts can better arbitrate. It does not go unnoticed that if I were a public service employee of the Australian government, this very presentation could be deemed illegal. Australia is a young country with room to evolve. Their founding fathers chose not to provide their citizens with a Bill of Rights, largely due to racism and belief that society could make do without them. They were wrong on both counts. It is time, 121 years after the ratification of Australia's constitution, that they take significant steps forward to fix these mistakes. Australia's citizens must come together to protect their freedom of expression and further demand the establishment of a human rights charter to protect the rights and freedoms that any citizen living in any free and liberal democracy is inherently due. Only then will Australia be able to fully align themselves with their shared counterparts.